Let's see. We're looking at 7:43 right now. Trump administration is taking on another university. This time, we're looking at North Carolina. The Education Department is launching an investigation at Duke University and the Duke Law Journal, saying the university was violating the Civil Rights Act.
The investigation looks into whether the school and its law journal broke a clause prohibiting discrimination based on race, color, or national origin in programs or activities receiving federal funding.
Now, Human Services Secretary Robert F. Kennedy Jr. is calling on Duke to form a, quote, merit and civil rights committee to work with the federal government. Joining us now to talk more about this, our chief legal analyst, Conley Frodes. Conley, first, where's the proof?
They're pointing to a document that was sent to organizations and other folks throughout the campus that was from the Law Journal. I have not I've not reviewed the document. There are allegations of the document, but in there it says that there's a 10-point basis, points that are given when evaluating potential candidates to be a part of the Law Journal, and that 10 points would be given if you are a part of an affinity group, and not just for being a part of it, but being able to describe your experiences and how it would benefit you while being on the journal. Additionally, give additional bonus points for being in leadership positions. So I have a couple keys that I can address on that, but I'd even say, before I break down my argument, which I think would be successful if this ever was going to court, the same rules that were put in place to ensure that individuals that look like myself, because let's be clear, that's what we're talking about, those type of folks, that was put in place to make sure that we got equal access and equal treatment in these positions. Duke Law School, founded around 1860 something. Yeah. First African American ever to be able to be admitted to the school, 1960 something. So let's put that into perspective. 100+ years, there was clear cut discrimination on the books, not some document, but law, that individuals that look like me couldn't even attend this school. But now you fast forward, after the passage of the Civil Rights Act of '64, Voting Rights Acts, and things like that, folks are now using those same laws that were put in place to ensure that I got equal access, or got access at all, to now flip it and say now you're discriminating against folks. But the numbers don't support that, and so that's problematic on its face. But if you look at the document, it says a couple things. If you are participating in an organization and you can describe how participation in that organization will help and benefit you within the journal. So it's not based on race, it's pointing to your experience, and you're using those experiences. And so I'm pretty sure someone smarter than, me came up with this to ensure that they were in compliance with the Civil Rights Act, as opposed to blatantly disregarding some non-discriminatory practices.
This could affect their federal funding, right? And so I know they're looking at that, but other schools in North Carolina, South Carolina for that matter, are they looking at their internal policies going, whoa, I don't want the target to be on my back. We need to make sure that we aren't in breach of any of this civil rights issues as well?
As someone that sits on an institution's board of trustees, I can tell you those discussions are always happening. You want to ensure that someone's advised you on the most recent changes to law, to statutes, and to keep you aware of the temperature of the day so that you are in line of what's going on. But I also can tell you that there are folks that are in the room to make sure that you are not just online, but above par. What I don't like about this is that they are pushing, they as in the Secretary of Education, McMahon, and the Secretary of Health and Human Services, Kennedy, are pushing both the law school and the medical school to ensure that they have, and this is the part that's that dog whistle that bothers me, this merit-based curriculum. So let me explain to folks at home what the law review is, what law journal is. It's already hard to get to law school. You go to undergrad, you go bust your butt to go to undergrad, you pass the LSAT, you make it to law school. So you're already pretty intelligent. But then within law school, there's this thing called Law Review, Law Journal, which is like the brightest of the brightest. It's not folks walking around with a 2.2. These are folks that got a 4.0. These are the people that are making Dean's List, that are getting the book award. That meant they wrote the best essay in the class out of 150 folks. And then out of those folks, it's so competitive that they're fighting literally to just get an opportunity to apply. So you're not talking, when you say things like merit-based, I'm concerned and confused because it makes it seem like these folks aren't qualified, like they don't belong there. And that's the problem that has been back to the 80s when we started fighting affirmative action, and that same rhetoric is being reused now.
Well, yeah, some interesting insight. A lot of people don't know how the Law Journal works. So this whole announcement for the investigation. No lawsuit yet. You mentioned if this makes its way to court, but Columbia University already reached a $200 million settlement with the Trump administration to restore their federal funding. Do you think that kind of sets a blueprint for other universities in terms of if they have investigations of their own?
Well, if we're building a house, we got two blueprints. We got the Columbia blueprint, we got the Harvard blueprint. One is to fall back and receive the threats and the pushes from the Trump administration. The other one is to fight. Now, in the Columbia situation, it was for the exact same thing that Harvard was looking for, not in this situation. They were asking for a list of protesters and people that have participated in things that they believe were un-American protesting. Again, confusing argument. That's why Harvard said no, thank you, but we'll fight you. Columbia said no, we need our funding. We don't have the endowment. Two different houses, same argument.
Okay.
All right, our chief legal analyst, Khalif Rhodes, breaking that down for us. Khalif, thank you.
Queen City News Plus. Just search Queen City News on your smart TV's app store.